Hello everyone, I am back with another major legal development. In today's video, primarily I will be discussing about the major points, that is, what is Hindu Succession Act 1956, changes brought by the 2005 Amendment Act in the above, and the most important point regarding the recent judgment of Vinita Sharma versus Rakesh Sharma. Now, starting off with the Hindu Succession Act 1956, it primarily provides for succession and inheritance in regard to property as to who is eligible to acquire property and other related matters of property. This act applies to Hindus, Buddhists, Jains, and Sikh. According to the act, properties are of two types. Firstly, ancestral property. This property is so which is acquired by inheritance. And the second type of property is self-acquired property, which means which is acquired by the own capabilities of an individual during their lifetime. This is the basic classification of property as per the Hindu Succession Act. This particular structure is the basic joint Hindu family structure. Here, let's suppose A is the person who is holding ancestral property, W being the wife of A, S and D being the son and daughters respectively. Here, S2 is the grandson of A, S3 great grandson, and S4 being great great grandson. Now, with respect to joint Hindu family, two terms can be used, namely members and co-partners. With respect to this particular family, be it son's wife or daughter's husband, each will be its members. But can we use the term as co-partners for members? No. Co-partners mean members of the family who have the right over the ancestral property. Co-partners can claim their right over the ancestral property. Therefore, we can say not all members are co-partners, whereas all co-partners are members. Now, before the Amendment Act of 2005 came, Hindu Succession Act held that co-partners are those members who are the lineal descendants of the same ancestral up till 3 generations. So, with regard to this case, the co-partners will be son, S2 and S3 only up to 3 generations. But after the ancestral holding the property, now suppose in this case A dies, then S4 will be added to the list of the co-partners. Now, as per the Hindu Succession Act, main lineage can only be included as the co-partner. Here, daughter or wife will not qualify as co-partner. Now, Section 6 of the Hindu Succession Act provides for the survivorship rule. According to it, if A has the ancestral property, therefore its co-partner will be A's son, A's great grandson, and A's great grandson. This was the basic criticism of the act because only males were co-partner. This means that only sons could acquire the property and not the daughter. Any individual can make a will as to the division of property after his death. But this will by an individual can only be made in respect of only his self-acquired property and not for the ancestral property. Therefore, the division of ancestral property will take place according to the Hindu Succession Act only. Therefore, the Amendment Act of 2005 cancelled the rule of survivorship and instead brought the concept of testamentary and succession and intestate succession. Now, what is testamentary succession? It is done by way of making will, and therefore, as per will, property can be divided to any person depending on the desire of the person making the will. No problem arises with the division of property as per will, but the major issues arise in the case of intestate succession. It means that when an individual dies without making a will, and the question of division of ancestor property remains unanswered. To provide for the answer, the Act after 2005's amendment provide for the concept of intestate succession. There are 4 classes according to which the property should be distributed accordingly. The first preference for the division of property will go to the widow son and daughter, each eligible for equal share. Both the son and daughter here will be entitled to equal right in the property. To sum up, the survivorship rule was removed and instead the concept of testamentary and intestate succession was brought by the Amendment Act of 2005. This gave an equal right to daughters as son in the ancestral property. Also held that the co-partnership right of daughters exists since their birth. The daughters will be equally liable. Now, the Amendment Act 2005's enactment date was 9 September 2005. The major issue regarding the amendment was whether, on the date of enactment, that is 9 September 2005, is it mandatory for the father to be alive? Meaning, if the father died in the year 2002, let's say, can the daughter still claim the property under the Amendment Act? Answer to this question has been finally resolved in the present case of Vinita Sharma versus Rakesh Sharma. But before this, there were other views taken by the Supreme Court. The first case was Prakash versus Phoolwati. It was decided in the year 2016 by the division bench consisting of Justice Anil Dave and Justice A.K. Goyal. They held that it is mandatory for father to be alive on 9 September 2005. That is, only living co-partners and living daughters will get the right. The next, in the case of Tamanna versus Amar, which was decided in the year 2018, and the bench constituted of Justice A.K. Sikri and Justice Ashok Bhushan. They held that, in spite of father not being alive on the date of enactment, the daughter will still be entitled to the co-partnership right. This case led to confusion as the views were contrary to what was held in Prakash versus Phoolwati's case. Therefore, in order to rest the matter, the Supreme Court in Vinita Sharma versus Rakesh Sharma, which was decided this year in August, where the three-judge bench of Justice Arun Mishra, Justice Abdul Nair, and Justice M.R. Shah held that women's right to ancestral property is by birth. The fact that father is alive or not does not matter. So, the whole video can be summed up in this particular context. This was the discussion on daughter's right to property. For further updates, please subscribe to my channel and also hit the like button and press the bell icon. Thank you.